excitement. Hello, this is U.S. Immigration Attorney Sharifa Tharpe. I'm just setting up here. So give me a quick minute, making sure that I am set up for this live today. All right. Thanks so much for the love. I appreciate it. Go ahead, start putting your questions in the comments. I want to spend a big portion of this live focusing on your questions. But I also wanted to talk about a topic here, and this is why you should not be afraid to apply for two types of applications called VAWA and the T status. So if you've been following me, you know what those are already. But for those of you you're just joining me, let's talk about what the VAWA is, what the T's are, and why you shouldn't be afraid to apply for them. Now, these are types of applications that are available if you have been the victim of certain types of mistreatment or abuse. And so this these applications are there for you to apply for to get status, to get your work permit, to get situated here in the United States. Now, the reason I'm saying don't be afraid to apply for these is because a lot of people, before even trying, before even getting legal advice, a lot of people determine that they cannot apply for this because the person who did the mistreatment or the abusing will find out and retaliate against them, and that retaliation is going to be worse than anything else. So you may be watching this right now, you may be thinking this right now, and you may not be making a move towards these applications because you have this misconception. What I can tell you based on my extensive experience filing the VAWA applications as well as the T's is that every step of the process is extremely confidential. Not just confidential, extremely confidential. It's actually in the law that none of the agencies that you are applying to regarding being the victim of labor trafficking or any other type of trafficking, being the victim of mistreatment by your US citizen or resident relatives, none of those agencies can disclose this information. They certainly cannot contact the perpetrator here, the trafficker, or the abuser, or the person who's doing the mistreating. They cannot contact them. That's against the law, and it comes with legal consequences to the agency if they violate this law. So this ensures that this is treated with confidence, and once you apply for it, you are in a type of protected status that enables you to apply without fear of any kind of retaliation or retribution. So that is why you should not be fearful to apply. Now, with VAWA, it's for anybody who has been mistreated by their citizen or resident spouse, their parent, if they're under 21, under 25 in some cases, or by their adult US citizen son or daughter who's age 21 or older. The other thing with that, the other aspect of this application that I think makes a lot of people fearful about applying is, will their relative get into any trouble if they apply for them? Now, once again, the agency cannot call up your relative and say, we're investigating whether this is true. Is it true that this happened? They don't do that. What they do look at is how credible is your evidence. That's how they make the determination as to whether they're going to approve your VAWA application and the T status as well. So that's the one way they get around having to call the relative or call anybody that's involved to try to corroborate the truthfulness of the evidence that you're submitting. So they will not call the relatives. And now, what happens with mail? What if you're still living with this person who's mistreating you? What happens with the mail from immigration? So immigration asks for your safe address. However, when an attorney is involved, the attorney, they always send all the correspondence to the attorney, and then the attorney can work with their client in regards to the correspondence. So that's how they get around that and maintain confidentiality through the process. So this is at every stage of the processes that they have to make sure that they qualify and that they maintain confidentiality here. All right. So don't hesitate. The first thing you can do is just know if you're thinking about this, if you have heard of the T status, you've heard of VAWA, you would like to move forward. The first thing you can do before just coming to any kind of conclusions is do a consultation, invest in a consultation, because in the consultation it's also confidential. So that means that I have to keep your information confidential. Nobody's getting into trouble. And I've had situations where individuals open up to me for the first time about what happened to them in regards to trafficking or even in regards to mistreatment by their US citizen or legal permanent resident spouse or parent. So it's that confidential, and I do make sure that you understand in the consultation that nobody's there to get into trouble. I'm not taking a log of your information to report it anywhere. So this is the consultation is a safe space for you to evaluate your options and determine whether what you went through does qualify you for this kind of relief. And if at the end of getting my professional opinion about your case, worst case scenario, you don't qualify, you just don't qualify. There are no strings attached. Nothing is going to get out of my office that's going to compromise your information that you have opened up to me about. So, just know that that's the way to start. And then we can talk about moving forward with any one of those types of relief for you. Now, the benefits of the T status is 4-year work permit, and you do get the opportunity to apply for your green card after you've been approved for the T status. You also, your children. So, my client just sent 2 pictures of her daughters who joined her after she was approved for T status, and they are already settling into life here in the United States. And it's such a pleasure to see that and to see the big impact that I, as the attorney, and my team has made on this client and her life, and her children changed their future for years to come. That does make a big difference, and it can happen for you as well. Your children can join you. So if your children are outside of the United States, they can join you on the T status. So when we submit the applications for our clients for T status, we do make sure to understand whether they have qualifying relatives who can come along with them. If we find out that those qualifying relatives can apply with them, or they wish to have those relatives apply with them, we not only just submit the applications for our clients, we submit the applications all at the same time for their children and their spouse, and their parents in some case. So their parents, their siblings who are under 18, if they themselves, the victim or the main applicant is under 21. So let me tell you, the benefits and the relief of the T status goes a long way, and the U as well. The U deferred action, or the no, not the U deferred action, the U visa. But the U visa takes a long time. With T status, though, it extends to parents. Okay, let me stop a minute because I want to make sure you have this very clear about who qualifies under the T status. So if you are the main applicant applying for T status and you are under 21, your parents qualify, your siblings who are under 18 and unmarried qualify, your spouse qualifies, and your children who are under 21 and unmarried qualifies. If, say, that what you've experienced does involve a threat towards your other family members, then they can come along as well. Adult children, other relatives who are facing that threat. So adult children, adult siblings can also go along with this application if they themselves, those relatives, are facing the same threat from the person who victimized you. We can apply for them as well. So, it goes a long way. Now, if you're 21 or over and you're the victim here, you're the main applicant, then your spouse and your children under 21 qualify, whether they're in the United States or outside of the United States. Your relatives, now, here's the other benefit of the T status. If your relatives are in the United States, they qualify to apply along with you, guess what? They can get their work permits too. So once they're approved, you're approved, they're approved for T status, their work permits come in the mail shortly thereafter. So not only can you get status, get relief here, get permission to live and work here, get a path to the green card here, but your relatives get the same opportunities. If your relatives are outside of the United States, once you are approved, they are approved, they come into the US, they can then apply for the work permit once they get here. And it's not they have to apply, it doesn't mean that they have to apply for status all over again. It just means that now that they're here, they're confirming they're here, they have to submit the work permit, so they get that in the mail with their social security number. So it goes a long way here. Now for VAWA, VAWA does lead to the green card, right? So VAWA, there are two stages of VAWA. The first stage you'll see is you'll be approved for VAWA. Once you're approved for VAWA, then they automatically move you over into the green card process as long as you submitted your I-485 application. Now, this process is taking about 3 years. The main applicant for the VAWA does get their work permit while they're applying for VAWA if they submitted an adjustment of status application at the same time. So even though the process takes about 2.5 to 3 years, the work permit, which is a 5-year work permit now, by the way, the 5-year work permit allows our clients to continue to live, work here, go through the process while the decision is being made on their application. Now, the other benefit here is that VAWA allows for children who are under 21 and unmarried to be included in the petition as well. So that means that if the children are in the US or outside of the US, when you're approved for VAWA, if the children are in the US, then they can apply for adjustment of status along with you. If they're outside of the United States, then you get your green card. Your children would be able to come to the United States with their own immigrant visa that turns into a green card when they get here. So the benefits go a long way. This is where you have to really think about whether you're being you're fully informed about the confidentiality, about what will happen, because a lot of people let the chance of applying for these kind of forms of relief, they let it pass them because they have this kind of fear without getting the legal advice, the consideration to take into consideration all the information they need. So don't let this pass you by. And I just saw someone here. Thank you so much. So many golden nuggets. Thanks so much. That's right. Every so often, I come on here as regular as I can to give these golden nuggets. Um, all right, so I saw someone here mention they got divorced from a US citizen in 2020. Is VAWA still an option? This is where it's so important to make sure. So yes, so divorce from 2020, can I still file for VAWA? Right now, unfortunately, that chance has passed. You have up to 2 years after the divorce is finalized to apply for VAWA. If that time passes, then right now, as the law is, unless they change the policies or unless we have some case law that changes that, right now they are not extending that in any way. So it means that you have to look at other options. But this is where I say still contact me and let's talk in an appointment, because if your spouse, say, put you to work, made you work in their house or force you to work in their business without getting proper compensation, maybe subjected you to acts that you did not want to perform, that can result in T status as well. So, I have had situations, clients, represented clients in situations like that. So where VAWA wasn't an option, the T status was still an option. So give us a call, schedule an appointment, and let's talk about the facts here to determine whether you qualify. Is the promo still on? No, the promo is not. That was for the holidays, but now we're back on the regular routine schedule and everything. So the consultation is $150. You can go ahead, schedule that on your own by going to the link in the profile. Schedule your appointment on your own, or you can go to the website, get the number, call, and staff will be more than happy to assist you. Is there a process to file where you can get a work permit and travel document that's not VAWA or marriage based? No. So if you're just thinking about submitting a work permit and travel document without it being attached to anything at all, then no. So this is not a situation where you can just print off the work permit application and write to immigration and say you wish to have a work permit. There are qualifications that you have to meet. So, for example, some individuals who were paroled to come into the United States at the border, or paroled from, say, Venezuela, from Haiti, they do qualify. And parole means they got special permission to come in at the border. They didn't have a visa, but when they got to the border, or they were evaluated before then, they were given a parole permission to come in. They qualify for the work permit as long as that's before the parole ends. That's an example of where maybe they don't have any kind of status, but they got paroled. So that does give them the ability to apply for the work permit. Can I apply for VAWA without affidavits supporting the abuse? Yes, that's possible. But, you know, rather than trying to figure out what you don't have, because not all evidence is going to fit every. So not you're not going to find one a nice neat list of pieces of evidence that every single case must have. It's going to differ, and it's going to be based on the facts here. In some cases, the abuser is so good at hiding what they have been doing to the spouse or the child or the parent that there are no witnesses. And in the case that there are no witnesses, maybe the affidavit support, the witness statements, which is what I think you're referring to here, would not necessarily be of any use because it was not observed by anybody else. Because sometimes abusers tend to be very charming in the public eye, but when they're behind closed doors with that spouse, they turn into a nightmare. Or that's where they really use their abusive tactics against the spouse or the parent or the child. So it's not one size fits all. The general rule is you need to present credible evidence. I would say what you should never be submitting, um, what you should never leave out on your application, what you should never leave out of your application is your declaration, that statement. And it can't just be a paragraph. I would say it can't even be a page. I've never submitted my clients' affidavits with on a single page. I have, because you know why? It has to be sufficiently detailed for the officer to accept it as evidence. So you should not be sitting down and writing a statement like, I was abused by my spouse. They yelled at me, they called me names. Please provide me relief. You have to get a lot more detailed than that. So I would say that's the one piece of evidence, the declaration that you should never submit an application without. How much do you charge for removal of condition for 2 years? So it's nice to see you, BJ. Now, the first thing, I don't do quotes here because every case is different. I have to understand your case. But what you can do is you can then schedule an appointment. It's $150, and then we can go through a more detailed evaluation. I first have to determine what's going on. Are you with your spouse? Are you filing without the spouse? And then I can provide you the quote. Hi, how long would it take for a parent to file for their child who is married and over 21? About 14 years, as long as the parent is a US citizen. Can my US citizenship children file for me if I'm through a divorce and live in a different country? If your US citizen children are age 21 or older, they can file for you even if you're divorced. If your child is being abused and you're here out of status, but the child is here legally, can VAWA help me? Yes, absolutely. So a parent watching their child being abused, even though they may not be abused directly, can qualify for VAWA. Now, it depends on the facts, by the way. Now, are you having to watch the child being abused? What's happening? I would really have to know the facts involved. But having your child be abused in front of you and is definitely a qualifying factor here for VAWA. Now, another thing though, keep in mind one more thing, you do still have to be married. So even though you cannot apply for VAWA if you don't meet the criteria of being the spouse of a US citizen or legal permanent resident, the parent of a US citizen who is age 21 or older, or the son or daughter of a US citizen or resident who is under 21 or unmarried or under 24. So you still have to fall within that category. But if, say, a part of it is the abuse, whatever relationship, that qualifying relationship you're having, If your child is being abused as a way to get back at you, that is a qualifying factor for VAWA. If you're on removal, can you marry and get papers? Now, if you're in removal proceedings and you do get married to a US citizen, you have to meet a much higher standard. It's very difficult to get approved for this, but a much higher standard of relief to get the green card through marriage, and it's going to be by clear and convincing evidence. Clear and convincing evidence. Are you located in NY? So we don't, our office is based in Florida, in Boca Raton, Florida. However, it has not stopped me from getting approvals and relief for my clients all over the country and the world. So I represent clients in all 50 states and the globe. No matter where you are, I can help you. Happy New Year. What if your priority date is current, but your portal doesn't allow you to submit any documents and you're in the US on a visitor's visa? Can you adjust status while in the US? Now, keep in mind, I'm not your attorney and I cannot give you advice specifically. But if you do indeed have a current priority date, you're here in the US, you have your I-130. That means usually if your priority date is current, your I-130 has been approved, then it is more likely than not that adjustment of status would be for you. But you see, with this, if you notice, I'm very cautious about this because I've seen a lot of mistakes being made with this process. Maybe sometimes you think your priority date is current and it's not. So for example, the NVC, that's where your paperwork is right now, usually opens up the portal and allows you to get started if your priority date is current. So you have to be sure that your priority date is current and that it will allow you to apply for adjustment of status. Because if you do this on your own, you submit the application and it turns out you made a mistake on that, then they're going to deny that adjustment of status and then you'll be stuck. So just be very careful whenever you're dealing with this. Make sure you schedule an appointment so we can go through the dates, look at the visa bulletin, the national visa bulletin, and make sure it all lines up for you to apply. My friend got married and then later found out that her husband was married and went on an interview twice. Can he get a divorce and how long does it take? He has no idea where the other woman is. So yes, that's a possibility. While I'm not a divorce attorney, divorcing and then divorcing the spouse and then making sure that now the current marriage is legal, it's valid because in the United States, if you marry somebody, then you don't divorce them, then marry a second person, that second marriage isn't valid. So you have to make sure to go through the divorce process and then make sure you properly validate that second marriage to make sure it's legal and then reapply. So yes, it's possible to do it even without not knowing where the person is. But you have to also be careful what's going on with that process. Make sure that you understand all the implications involved, all the facts involved. All right, so I'm on YouTube now, and then I'll go to TikTok. All right. Thanks so much, Noreen. Same to you. Will the trafficker know that he or she was reported by the victim? No. This is confidential. They will not know. No, keep in mind, it depends, right? And it depends on what the victim wants. does the victim want a full-fledged investigation? Does the victim want justice? If that's the case, then eventually the trafficker will know because the victim wants that. The trafficking victim wants justice. So it depends on the goal of my clients when we're evaluating the what happened to them and the likelihood of the trafficker being brought to justice, because that can happen as well. A part of this is that the trafficker, the agencies involved, because remember that the T status, while you are required to report, you are not required to have an investigation or anything like that, right? And so that's where I explore with my clients to what extent do they want justice. And that determines the agencies, whether it's going to be Department of Labor, whether it's going to be the police, whether it's going to be the FBI, or any other type of law enforcement agency to report to. In cases, and then the law enforcement agent, for example, the Department of Labor, if they themselves, because I don't control the Department of Labor, but if they themselves determine that they want to move forward with further investigation, they still make sure that they completely protect the confidentiality and the identity of my clients. Because even if they're doing an investigation, even if they're asking questions, they will never disclose the source of the information, of where they got the information. So in most cases where the victim definitely is stressing confidentiality, the trafficker will never know that the victim reported them. Do you represent clients for regular immigration purposes apart from VAWA or T status instances if you are processing documents? Absolutely, yes. So we just got approved for a marriage base just a few days ago with all the interview. And then a few weeks ago before that, we did a marriage base. So we do regular, what you, I guess I don't know if I would say regular, because an option is an option for our clients, but non VAWA, non T status type applications, we do those as well. Absolutely. So give us a call and let's talk about what your options are. It's been 8 months counting from request of medical for I-485 adjudication since May 2021 of my VAWA, no approval. What should I do? So I am not your attorney and I don't know what your case looks like. So, if you really are concerned about how long they're taking, you can always contact them to find out, or submit a case inquiry if it's gone way over the processing time. If I went outside the country on advance parole, can I apply for a resident card? That sounds complex. If you have advance parole, it usually means you're going through the process. I would have to understand what your situation is. Once filed with VAWA and approved, um, so let's go here. So once filed with VAWA and approved a work permit and travel document and not a green card, you can't file a green card the regular way, right? You have to refile with VAWA. So VAWA is a continuous process. Now you qualify for VAWA, so if you have an approved VAWA, there's no losing there. Go all the way and get that green card. But what we do for most of our clients, they're able to qualify for applying for VAWA and the green card all at the same time. Once they get approved for VAWA, it automatically then goes on to the green card, and they end up getting the green card. If you do find another option to qualify for the green card and you qualify in every way, you can pursue that as well. But If you have an approved VAWA, go all the way. Okay, can't wait to see you too, Lindy. All right, my time is up. I'm gonna go ahead and see if I can go through quickly some questions here on TikTok, and then I have to head out. But remember, get in touch with me, schedule your appointment. That's going to be the way to determine whether you qualify for any kind of relief that gets you work permit. If I apply for VAWA, how long does it take for the work permit after filing? So 8 months to a year. A, a long, how long does it take to approve for a VAWA case? It can take up to 3 years, but in between, you do have the opportunity to get the work permit. So that helps. And it's a 5-year work permit, guys. There's no losing there. You get the 5-year work permit that takes you even beyond what your expected process would be. So you'll have your 5-year work permit and then hop straight into a green card. Hello, my renew work permit 9 months under process. What can I do to send me the new one? So unless you're gonna expedite it, it's backed up right now. So frustrating. Hello, renewed work permit 9 months under process. So you'll have to expedite if you have an emergency or you have a need. I believe that they are approving or expediting for healthcare workers and childcare workers. So those are ways that you can point out that you should have yours uh, issued faster. I'm a green card holder. How soon does my fiance would get through if we get married? So right now there is a wait list. So you're looking at about 9 months to 12 months for the I-130 to be approved. And then they have to wait a little for their priority number to become current. So I would say maybe 2 to 2.5 years at this point, based on everything I'm seeing. What if you don't married, but it's a partner and the abuse starts weeks after dating? What's next? Call me. That's what's gonna be next. I have gotten T status for my clients who have been subjected to certain types of abuse, along with certain types of demands by the partner. But I need to understand the facts here. I need to understand what kind of abuse are you experiencing to determine whether you can qualify for an alternative option outside of VAWA, because you need to be married. But if you're in a state that allows for common law marriage, that could also be a way to qualify for VAWA, even though you haven't formally gotten married. All right, guys, I have to head out to an appointment. So thanks again for your time. I'll be back tomorrow at around lunchtime. I will see you tomorrow, Lindy. And remember, schedule your appointment so that we can talk about how you can qualify for the work permit as on an individual basis. Thanks, everyone. Have a good day. See you tomorrow.